Okay, welcome everybody. Hello, my name is Jess McQuail and I am Director of Just Fair. I'm very pleased to welcome you all to the Future of Human Rights and Justice in the UK. This is a joint event hosted by Just Fair and the Bonavero Institute of Human Rights to mark Human Rights Day, which many of you will know is tomorrow, and the online launch of a new open access book, the title of which is Access to Social Justice, Effective Remedies for Social Rights, which is authored by Katie Boyle, Diana Camps, Kirstie Ken English, Joe Ferrie, Aidan Flegg, and Gaurav Mukherjee, many of which are on the call today. For those of you who don't know Just Fair, we are a civil society organisation working to achieve lasting positive change through the promotion of economic, social and cultural rights across the UK. So, but before we start the session and I hand over to our co-host, Rachel, just a little bit of housekeeping. As you hopefully all know from the joining email, this event is being run as a webinar and is being recorded. No participants will be visible unless to everybody else. And if helpful, you can turn on the closed captions function on your screen if you'd like to. My colleagues Helen, Flynn and Alex Firth are supporting with the tech. So I think you have Helen's email from the joining email. So please just email her if you're having any tech issues, because you can't use the chat function on this Teams facility. You will have the opportunity to ask questions via the Q&A function at the end of the session. So Helen will read out some of those questions for panelists to answer at that point. So save up your questions to the end. And please do feel free to share your thoughts via social media. Do tag Just Fair and, of course, the Institute. I think we've given the Blue Sky and LinkedIn tags in the email. Lastly, we'll be sending a short survey out to everybody afterwards. Please do complete it if you can. It really helps our learning. So I'm now pleased to introduce our co-host, Professor Rachel Murray, who is Director of the Bonavero Institute of Human Rights at Oxford University. And Rachel's just going to say a few words. Over to you, Rachel.
Thank you so much, Jess, and it's a real delight to be able to co-host this event with Just Fair, and just to give a few opening remarks. And it's actually a really nice circle for me. I've not long joined the Institute, where I understand Katie spent time here as a visiting researcher working on this project. And the book is published by Bristol University Press, which is the institution I have just left. So I have it here. I really want to congratulate the authors for this publication. I think it manages to tread the difficult line between presenting robust academic research in an accessible and readable style. Its empirical methodology, speaking with people who experience what it says the everyday reality of those who support those trying to access their rights, is very much to be commended. And the book talks about the administrative mud, which I think is a great term, that those trying to access the various systems have to face, something I've also seen when examining the implementation of remedies from the international level, that a not insignificant amount of bottlenecks exist in trying to access and exercise rights comes from the bureaucracy of the systems at the national level. And the book presents the very real frustrations faced by those trying to access their rights, but also, and as I've seen outside of the UK and other countries, the frustrations of those within the systems themselves. And the book clearly has resonance and relevance beyond these borders. I think it also importantly acknowledges the context in which all of this takes place, including what is often hidden or less visible, such as privatisation, adding layers of legal complexity and ultimately undermining accountability for access to justice. And finally, the book highlights that individuals are pursuing cases, sometimes not just for their own benefit, or not even for their own benefit, and indeed at considerable personal expense, for the greater good, relevant because many of these challenges, as the book highlights, are the individuals face are systemic and they're not just individualized. Yet, as is always the case in situations where rights are undermined, we see the resilience of those who pursue justice, not just for themselves, but for others, whether they are the very individuals who have suffered the injustice, but also those practitioners working tirelessly in the field. And this book provides an important acknowledgement of their persistence. So again, congratulations to the authors, and thank you for enabling me to give these first few preliminary remarks. Thank you.
Thanks. Thank you very much, Rachel. And we are going to start with two practitioners who are going to contribute some of their own experiences to this session of the challenges that they face and the people that they work with face in their daily lives and work. And I'm very pleased to introduce first Rick Burgess. Rick is the co-chair of the DPO Forum in England and is also an advisor, the Social Science and Public Policy Advisor at the Centre for Society and Mental Health at King's College. So we're going to start with Rick. So over to you, Rick.
Thank you, Jess, and hello, everybody. I apologise in advance. I'm a bit ill, so I may be coughing my way through this. Don't worry about it. I'll live. I ended up coming up with a title for this, which is All Work Activation, No Social Security, which is where we are really in this country. Struck a couple of weeks ago, a guy called Peter Sullivan, who had been jailed for 39 years for a crime of which he was completely innocent. One of the things he said was very interesting in that when he went in, there was the Department for Health and Social Security. When he came out, there was a Department for Work and Pensions. Now, it might seem a small thing, but do you notice what is no longer included? There is work, there is pensions. There is no desire to provide social security. In reality, what this system has meant for people is that they attempt to have as little contact with it as possible, because every contact is a risk of something nasty happening. It has become a shadow penal system, which together with the media and political class have created an entirely hostile environment for people who draw upon social security. In the book, there's a great metaphor of a mountain and the sort of the steps towards getting some kind of redress. And of course, the step for administrative mud is the one where most people, I think, we find ourselves in. But I also thought that this mountain is actually, and this is, I apologize if you're not familiar with this, but in the Lord of the Rings, the dark evil place is called Mordor. And this, I think the thing is, this mountain that you have to climb it's not a neutral space. This mountain is in a hostile space. You're already on enemy territory. The idea that you could draw upon human rights and legal support to get redress from the system seems incredibly distant for most people being subject to it. It's the administrative mud concept is maybe one of the biggest features I think people need to understand of kind of how it feels for the individuals trying to address it. Currently, I work at the Greater Manchester Coalition for Disabled People. So one thing that's happening is advice and advocacy cannot meet the demand at all. So one thing we do is we do kind of like a group session where we do half of the session is sort of advice and questions to people on how they can solve their issues. And the second part of the session, we actually have a creative social part, because we found it's increasingly now the case that we need to look after people's mental and physical well-being while they're engaging in struggles with this system. And while it means we spend less time on specifically talking about their social security issues, it's actually as important, because they will just stop appealing, stop doing the mandatory reconsiderations if if they don't have the capacity and they don't have the hope that this can lead to some change. And I think, again, this goes back to what I love about this work and others work in this area. I know Amnesty did a great report it's this year actually, is to actually think about this within a human rights framework, to actually think that you've got a right to be treated as a human being is actually quite revelatory at this point. People are so traumatized and so victimized by this system and abused by it, that the fact that you should be treated with respect as an equal human is actually quite a radical idea. Even to the point in the work I did with the Independent Social Security Commission, we were creating an alternative to the PIP, Personal Independence Payment Benefit, an assessment process particularly, and then taking it round to people and presenting it to them. It was a completely blank slate. It was completely redrawn so it would not traumatize people. It would not abuse them. It would not victimize them. And people could not easily accept that this could happen. They were so used to everything being a tripwire to catch you out, that the idea that this could be, you could have a supportive system that found out what you need and then provided what you need, was actually took quite a while just to get that concept across to people, because I think over decades people have become very used to being in this position of being hated and abused by those systems that are actually meant to be there to provide some level of social safety net. I think the other side, the darker side of this is also that there have been a number of deaths. I would put it in the thousands. I was involved in the work with Deaths by Welfare, which was started by Dr. China Mills and also by the journalist John Pring. And as well as literally cataloguing the number of dead people, it was also very clear as we went through the history and as each development, each think tank piece, each legislative attempt, each meeting, and I always point to the famous meeting in 2001 entitled "Malingering and Illness Deception in Welfare Benefits." I mean, they were approaching this with an open mind, weren't they? That it's very clear this is deliberate, this is practiced, this is absolutely not an accident. So we do generally use the term democide, that this is a state-led process. It is not accidental. These deaths are deliberate by the state. It's gone on for too long for us to pretend that this is a mistake, and there's been too many cover-ups. So I think as we look forward, I don't see actually that, particularly in terms of the Department for Work and Pensions, that can continue to exist in any way. We need a new Department for Social Security. But also, you can't just go from a system of massive injustice without addressing that. And I do think we would need a truth and reconciliation process for those people who've been subject to this. That seems a million miles away at this point. That seems further away than the top of this metaphorical mountain. But you cannot treat people like this and then just say, oh, now we've stopped. Moving on. There needs to be, people are just in their own thinking and they need to feel they're treated justly. And I think that is perhaps where the human rights framework can begin to help us to genuinely think about how every person is imbued with these essential rights that mean this systemic, practiced and deliberate abuse up to and including causing people's deaths, both has to stop and does not have to be this way. We can actually have a social security system. We can actually have a society that doesn't demonize people, and we can potentially even have a political media class that don't trade in that as currency in order to get elected. So didn't really have a big finish on this, except to say that this is vital work. And I think one thing again, as we found with our socials, is you do have to pay attention to people's well-being. You do have to pay attention to hope, to having a change on the horizon, being able to see the horizon, because often that administrative mud, it's gone over your head. It's more like quicksand, you're drowning in it. So I think this helps us to keep hold of a level of hope and a kind of a horizon that we can actually progress towards that, even while at the political level, it all seems to be going the other direction. I think this gives us perhaps a map through that hostile mountain territory that means there could be an alternative. Thank you.
Thank you very much, Rick. That was really important contribution. Thank you very much. I'm now going to hand over to Carla. Carla Clarke is a social justice agitator and lawyer who leads social rights challenges and has previously worked at the Public Law Project and the Child Poverty Action Group. Thanks again, Rick, and over to you, Carla.
Thanks, Jess. Bit hard of an act to follow there, but I'd like to start by introducing you to Melissa, her husband Gary, and their two children, Elaine and Erica, though not their real names. Melissa and Gary had lived in the UK since birth, when, on their honeymoon, they fell in love with Australia and decided to make a go of it over there. Their eldest daughter was born in Australia, but circumstances brought them back to the UK when Melissa was pregnant with her second child, and Erica was born here. Melissa knew within a few weeks that there was something profoundly different about Erica, even as her concerns were dismissed by the medical professionals. She felt that she couldn't cope with a severely disabled daughter and the reality of the English climate, so the family returned to Australia despite Gary's reservations. They faced one challenge after another, culminating in a trusted carer administering an overdose to Erica. It was the final straw. The family packed up once more and returned to the UK, expecting to encounter a system where their daughter would at least be safe. They did not expect to find a system where, for the purposes of entitlement to disability living allowance, she did not even feature until she'd been living in the country for 2 years. Disability Living Allowance, or DLA, is a social security payment aimed at supporting with the additional costs that are often incurred by those living with disabilities. The increased travel costs to attend the multitude of medical appointments, the heightened food bills because of specialised diets, the inflated electricity and heating costs because of the constant washing of soiled clothes and sheets, and the need to keep the house warm due to immobility. Melissa was a fighter, though, and she was not about to take no for an answer. She knew about the UN Convention on the Rights of the Child. She knew that the refusal of DLA for her profoundly disabled daughter was not in Erica's best interests. She requested a mandatory reconsideration of the refusal decision, and then, when the original decision was maintained, we lodged an appeal, and she, her husband, Erica, and I went to the tribunal in Stockport, where Melissa had the opportunity to express herself and for the judge to see for himself the power of a mother's love and the manifest extent of Erica's disabilities. His hands were tied, though, by a decision of a higher tribunal. And so, following the sympathetic but negative appeal decision, Melissa mustered her strength to go to the next level. There was a period of limbo while we waited on a decision for permission to appeal, and my contact with Melissa during that time was limited. When we did eventually got permission, I took an updated witness statement from her. Although I had a bit of contact with Melissa in the interim, I hadn't appreciated just how bleak things had been for the family. Melissa had needed an urgent back operation due to the toll of constantly lifting her 14-year-old daughter. This involved her being out of action for 6 weeks. When, in the absence of any assistance from social services, Gary requested to reduce his hours at work to be able to look after both Melissa and Erica, his boss refused and he was laid off. Gary felt deeply ashamed of not being able to provide for his family. The income-related benefits they could claim included no additional element for Erica as a disabled child because she was not receiving DLA. Being signposted to a food bank just before Christmas was the ultimate humiliation. The parents had reached a point of such desperation that they asked social services to take Erica into care because they could not cope. Ironically, such local authority care is something which would necessarily cost the state considerably more than paying DLA in the first place. To their credit, social services could see the amazing job that the family were doing, knew that this could not be replicated, and so refused to take Erica into care. But they were sensible enough to recognise the need for a respite package for the parents and a discretionary £100 a month payment to help the family out till DLA could be claimed. When we finally got a second appeal hearing, the higher judge accepted that Erica had been treated differently compared to those young people who had not spent time living abroad, and that, taking into account the best interests of the child, the discrimination was not justified, particularly bearing in mind how long 2 years is in the life of a child and how children rarely have a say in where they live. 4 years after the family had originally returned to the UK, Erica received a backdated payment of DLA for those initial years. I've told you this story not because it is a particularly hard one. In my experience as a legal representative, they are all hard. I've yet to meet the stereotypical welfare benefit scoundrel, but I've met lots of individuals who are trying their best in difficult circumstances. Rather, I've told you the story to add some colour to the access to justice journey that will be discussed by other speakers and to illustrate 3 particular points. First, even when certain human rights treaties are not incorporated, using the language of such rights is powerful. It gives legitimacy to people's sense that something isn't fair, isn't acceptable, is wrong, and that something needs to be done to address it. Second, accessing justice, from understanding what your rights and entitlements are, how to claim them, how to challenge decisions, and how to see that challenge through, requires grit, determination, resilience. It shouldn't be and doesn't need to be a Samson versus Goliath if government departments took a proactive approach to ensuring that they met legal and human rights obligations. In the appeal in this case, the Department for Work and Pensions, or as Rick has said, the former Department of Health and Social Security, placed reliance on the fact that there had been a public consultation process and on the role of the Social Security Advisory Committee in considering the relevant draft legislation. However, the consultation was aimed at adult disability benefit, not children's, and the advisory committee, not picking up on the impact of the 2-year presence requirement, raises questions about the range of expertise which is represented on such expert committees. Third and finally, challenging decisions takes too long. For the government departments, the tribunals or courts, and even us lawyers, it is a job, one case amongst others. For the individuals, it is a roof over their heads, sufficient food on the table, a family being kept together. Basic rights are also basic everyday needs. I'll leave it there. Thank you.
Thank you very much, Carla. And thank you again to both our practitioners, our speakers in that section. I'm sure it's given us all a lot to think about. Thank you. Okay, we're now going to move on to the authors panel section of the meeting. I'm very pleased to introduce Professor Katie Boyle. Katie is a Professor of Human Rights Law and Social Justice at the University of Strathclyde. She's an expert in the rights that we're talking about today, economic, social and cultural rights. And she's also, we're very pleased to say, a trustee of Just Fair. Katie is going to be presenting this section with Dr. Diana Camps, who is a lecturer in education at the University of Glasgow. I think they're going to be doing a shared presentation here. So, Katie, I'm going to pass over to you. Thanks.
Thank you so much, Jess, and good afternoon, everyone, and thank you very much for joining us. So Diana and I will be discussing the book on behalf of all of our co-authors, Aidan, Flegg, Kirstie Kent English, Gaurav Mukherjee and Edson Ferrie, who were all involved in the Nuffield-funded Access to Justice for Social Rights project that underpinned, the research of which underpinned this book. And I think one message we would really urge everyone to reflect upon is that we should ignore the testimonies of the practitioners and rights holders on the ground at our peril, because what we have in the UK framework is essentially the invisibility of injustice in relation to economic, social, cultural rights, social justice, or statutory entitlements, whichever language you would normally use. We do not have visibility of what's happening on the ground. So I can see Deanna is getting ready to share the slideshow. So Deanna, I'm going to carry on speaking while that gets set up, just so we don't lose time. So our primary research question for this study was whether or not those who experience social rights violations relating to food, fuel, housing and social security have access to an effective remedy in law across the constituent parts of the UK. And by access to an effective remedy, we used the normative framework derived from international human rights law. And so we were interested in whether or not people can access effective legal processes and whether or not those processes can deliver effective relief or effective outcomes when accessing justice. So we used both the procedural and substantive components, or the outcomes-based approach, to look at that. We examined and analysed the findings working with practitioners across the UK, drawing on principles of deliberative democracy theory and post-Rawlsian theories of justice. And we used the concept developed by Karen Zeevy, where rights claiming itself is a performative act within a deliberative democracy framework and is therefore crucially important in terms of reclaiming the narrative, even when the system is stacked against you. We theorised our findings using critical discourse analysis to help us understand how discourses were mobilised to push people into the margins, further from accessing any kind of justice. So a helpful analogy that Rick alluded to that we developed in the course of the project was to think of accessing justice as a mountain range. And the literature tends to focus on the first peak that's within view. So we see a lot of work, and very important work, around questions relating to legal aid, legal advice, standing at the first hurdle on the access to justice journey. But what our research told us, that even if you were to reach the peak of that first mountain, you begin to see several mountains behind you and several in front. We immersed ourselves in this journey via our research participant stories. And then we used a critical discourse lens to try and understand what was going on under the surface. So we were interested, using this discourse lens, to see what were the broader dynamics that created the terrain, and how does power play a role in this justice journey. So I'm going to return to that in a moment, but first we'll hand over to Deanna to discuss the critical discourse approach.
Hi, everyone. So as Katie mentioned, my background and expertise is in critical discourse analysis and sociolinguistics, and I joined the project to bring this lens to the work that we undertook across the UK. So the field of sociolinguistics, for those who don't know, is generally interested in connections between language and society, such as multilingualism, but also more broadly about how language intersects with other social dynamics. So in my own work, I've been interested in how language plays a role in producing and reproducing injustice and inequalities. So for example, how does power manifest in particular situations? How do people situate themselves in relation to their own values and sort of broader circulating discourses and ideas? And so this is a perspective that we brought to the Nuffield study. So by paying close attention to language or discourse more broadly, we're able to examine how language makes visible underlying discourses and power dynamics to identify how certain groups in society are privileged over others. And it helps us to recognize power and, in line with Foucault's interests, better understand the processes by which claims to knowledge and truth are produced. As we well know, this production of knowledge is never neutral, but it's mobilized for specific purposes. So we spoke to 26 frontline practitioners across the UK, from food bank staff to barristers in the Supreme Court. And these conversations have been really crucial in helping us to understand how practitioners give meaning to the actions that they undertake to support rights holders in accessing justice for social rights violations. Practitioners operate in an interesting space here where we see different discourses and interests intersect. And the research shows us how language, including dehumanizing discourses, had the power to potentially undermine social rights protection in various ways, creating the daily realities of policy and action on the ground. So, for example, it's now well established that social rights are marginalized in the UK domestic framework, but that this is no longer the case internationally or comparatively. And Paul Hunt refers to this invisibility in UK instruments as a cloak of invisibility. Furthermore, negative ideologies in the public space, both and also in practice, highlight that the realization of social rights is not only about these operational and legal processes, but also includes practices of valuation and categorization. And essentially, this means that law and policy attribute a sense of worth, and some human beings are just deemed to have more worth than others, which is problematic for human rights. I'm going to share an example. So one fitting example from our Scottish case study is the idiom of failed asylum seeker in proceedings to challenge a housing violation in relation to a lock change eviction policy. And the terminology of failed asylum seeker has no statutory underpinning, yet the first line of the alley judgment of the Inner House Court of Session states, the appellant is a failed asylum seeker. And this default terminology of the Home Office describes someone who's exhausted their appeal rights, but it's neither objective nor permanent, as someone can submit a new case and be granted asylum in the future. Importantly, we argue that these legal designations and political framings construct the contours of who is included and who is excluded in our collective imaginations of entitlement to justice. And we draw quite heavily here on Nancy Fraser's work. The term failed asylum seeker becomes synonymous with a specific type of person who's not deserving of humane treatment. And we refer to this in our work as evaluation discourse, which operates on a logic of difference, categorizing the deserving and undeserving. In relation to the alley case, the change lock evictions were not deemed unlawful. However, drawing on Zeevy's framing, the performative act of claiming human rights led to the policy being abandoned in practice, and demonstrates the value and importance of reclaiming the narrative. In other words, the symbolic and material change meant the case was a success, despite the valuation discourse perpetuating the legal outcome. The second important element I wish to highlight is that ideology often translates into practice. The valuation discourses relate not only to immigration, but also to low income, in work poverty, single parents, disability, mental health challenges, addictions, and criminal records. By way of example, the research indicated that 70% of PIP decisions are overturned on appeal, confirming qualitative findings that decision-making processes such as medical assessment procedures are unfit for purpose. And the system-wide problem with decision-making is what we refer to as systemic injustice. A welfare benefits advisor in England recalled a story of a client who had a severe sight impairment related to a brain tumor. She was required to undergo a reassessment for her PIP and was denied on the basis that she was wearing lipstick and her hair was neatly combed. She wore a wig. So not only did the assessment process violate her dignity, the erroneous and subjective decision-making resulted in an immediate halt of her benefits, which led to rent arrears. And because she was unable to use public transport and could no longer afford taxis, she became housebound, affecting her mental health, which is what we refer to as clustered injustice. And this was just one of many examples that showed how the impact on one social right has a knock-on effect on other areas of a person's life and well-being. And the third dynamic I want to highlight is how ideology is internalized and perpetuated, as well as challenged and rejected. So by this I mean that we need to have an awareness of how we talk about rights, as this is essential for countering the dominant valuation discourses that categorize people according to their perceived worth. Otherwise, we risk perpetuating harm. And what you see here is an example of a welfare rights advisor in Wales who refused to participate in the hierarchization of people, saying at the end here that she's not going to put people in a pecking order in order to provide them support. And then this final example is of a rights holder, as you can see, who's using language that perpetuates these harmful discourses about worth. A welfare rights advisor explained how some claimants feel undeserving, and they articulate their sense of justice by distinguishing themselves from what they see as the generally undeserving case. I asked the advisor why he thought that claimants have such a negative image of themselves and accessing services, and he said the following, which I will let you read. But what I want to add is that Foucault's concept of governmentality may be useful in us thinking about and understanding why claimants internalize this valuation discourse, which is also something that Bourdieu refers to as symbolic violence. So if we listen to what this research is telling us, it is that power lies in discourse and that we collectively should reclaim the narrative to reclaim that power. And this is not something that we can just leave to rights holders themselves, because systemic and structural injustice undermines their power to reject or challenge these framings. So by combining both the critical legal and discourse lens, we were able to see how individuals navigate the justice system more clearly. They are fighting against the tide, both procedurally and substantively. And discourse helps us not only understand these connections, but also how to identify and counter harmful discourses. And I'll hand back to Katie here.
Thank you. So I'm going to return to the mountain analogy. So this concept of the access to justice journey, we were looking at both the procedural and substantive barriers people face in accessing justice. And we drew upon a lot of literature that was really important in advancing our understanding of procedural fairness components of justice pathways, including Hazel Genn's work and the work of other scholars like Pascal Pleasance, Alan Patterson. And they also returned to those that conceived of the access to justice movement, Garth and Cappelletti, who in the original conception of access to justice spoke about equally accessible processes, and secondly, that can lead to socially just outcomes. And the literature often overlooks that second component, and we argue in the book that that is because so much attention is focused on the first, because the first part is itself not working, without getting to the stage where we're actually looking at the effectiveness of the outcomes of those processes. So the first barrier that people identify, or that the research demonstrates to us, is that this concept of legal consciousness. It's not possible to claim a right if you do not have awareness of rights or legal processes. And how can anybody claim to or use the language of rights if we don't democratise that language and ensure it is shared more broadly so that the narrative can be reclaimed? Next slide, please. The next barrier we encountered across this analogy of crossing the mountain range was that people need the resources in order to equip themselves for a journey, and those resources are largely depleted in our current framework. So people need legal resources, financial resources, and emotional resources. So we're familiar, for example, with the decimation of legal aid and what that means for people seeking access to justice, which is non-existent for social rights more broadly, to a large extent. But they also need emotional resilience, stamina, strength. In fact, vulnerability as a categorisation is such a problematic term to use because, as one of our participants spoke about, people need to be warriors to cross this journey and to have the resilience and stamina to do so. We also see a really strange individualisation of collective justice. So justice and the justice system operates largely on this idea of injustice being an individual experience, where what we saw was collective injustice, where the justice system is essentially inefficient and you have a conveyor belt of cases with individual circumstances for what are essentially collective injustice and collective and systemic problems. We also saw in the course of, thank you, next slide, of the emotional, legal and financial resources, there is a fear and a fear of retribution. And the fear of retribution, we saw multiple examples of a backlash when people complained. So this fear is a real fear. It's based on empirical data and it's not currently factored into our understanding of justice or justice processes. Next slide, please. As many have already highlighted, one practitioner spoke so brilliantly about this concept of being mired in administrative mud, and the actual lived reality and experience of people is that the system is so complex. There are multiple pathways, different time bars, different expertise required. Sometimes it's legal representations required, sometimes it's not, but almost in all circumstances there's an inequality of arms when the other side are represented by lawyers, such as, for example, in eviction cases. And this complexity exacerbates the journey because people get so easily admired in this administrative mud. Next slide, please. The lack of substantive standards is one of the greatest barriers that we face in the UK framework. We simply don't have the statutory or constitutional normative framework through which to argue social rights. So what we're essentially asking is for those who represent people who have lived experience of social injustice to help navigate the system for them without the appropriate tools. And essentially what we're seeing is those that are supporting social rights or people experience social rights violations are having to put round pegs into a square hole when making legal cases, instead of, for example, being able to argue a social security case under the right to social security as it's defined in international law. And of course, the rights that we speak about in the context of international human rights or domestically conceived social rights don't need to be absolute in nature, but if we allow for an approach which allows us to bring the evidence under the right itself, we would have a much fuller, justified and reasonable approach to social rights determination. Next slide, please. Because this journey is so difficult, what we ask people to do is essentially accept less than satisfactory remedies. People often will be so exhausted, their resources so depleted, that they can't face fighting, for example, a collective remedy. They might accept a less than satisfactory remedy outside of court, and they often it doesn't restore them to the original position, and it doesn't provide restitution. When we ask people what an effective remedy means in the context of the research we undertook, recurrent definitions included people want an apology, they want the situation to be fixed, and they want for it not to happen to anyone else. And this reflects international human rights law in the context of guarantees of non-repetition, as well as cessation of the violation. Ultimately, we have a system that is focused on this dominant idea of damages being the most important component of an effective remedy, and we don't explore empirically what an effective remedy needs. And more research is required on this. Next slide, please. Finally, one of the major issues we face when you look at the access to justice journey is that we do not have iterative feedback loops, and the system does not learn from itself. When Philip Alston did his visit in 2018 and whilst UN Special Rapporteur on poverty, he raised this issue of DWP's approach to a test and learn policy, which essentially is operating at that time as a decade-long excuse for not correcting issues inherent in the system. And this was something we saw across the board. So we used already the example of PIP decisions. PIP decisions over the past 10 years account for approximately 350,000 cases. And we have a turnover of 70% of those decisions being deemed unlawful at tribunal level. So there is so much inefficiency in the system which treats these systemic issues on an individual basis. These cases represent the people who actually manage to get to the stage and have the resilience to actually have this case heard. And we saw even in cases, we followed one case in particular, the Sharon Pantellerisco case. She was paid 4 weekly instead of on the same day every month. And as a result of that fact specifically, a benefit cap was applied to her. And when the court looked at it initially, they saw this as illogical and irrational, but on appeal it was deemed that DWP's policy of test and learn was sufficient to fix the error. It's still not fixed some 6 years later. Next slide, please. So the themes that we saw running across our case studies and repetitive governance frameworks was that we see a system that enables marginalisation. This is enabled through systems such as fragmentation, privatisation, complexity, individualisation, the automation of decision-making without accountability, as well as the accumulation of dehumanising policy. And this can manifest into a system which practitioners described as cruel and absurd. Our analysis suggests that there's more interdisciplinary research required to delve deeper into this decision-making sphere and in cultures of denial and disbelief in relation to the provision of care to those in need. We were also keen to actually, it feels like, just tap the surface here of what is required for a deeper dive into problems around decision-making and the cultures that permeate them. We found that listening to the stories of our research participants, that the environment in which both immigration and social security, by way of example, is administered is more than just hostile. It can be cruel, dehumanising, absurd, irrational and violent. And we use that example of symbolic violence that we discussed earlier, because what happens is this becomes embodied injustice, as Rick alluded to. So people carry this injustice in their bodies, in their health, and they bear the brunt of the social rights violations in their everyday living existence. Next slide, please. We had many recommendations, and I'll mention a few here. The research recommends reclaiming the narrative on social rights as legal rights, unpacking systemic barriers, including on legal aid, advice, representation, and creating a legal framework that reflects the UK's economic and social rights obligations in international law, whether that's via processes of incorporation or domestically conceived social rights. We need to explore better mechanisms for collective advocacy, collective complaints, and improve options for public interest litigation. And we need to remove the emotional, financial and legal burden which is hinged on the resilience of one individual. It's a completely impractical way of delivering justice. We should expand our definition of what constitutes an effective remedy, relying on more empirical data and using the international framework as a normative framework. And we need to explore the full potential of non-judicial routes, but also recognise that unless statutory remits allow, they are not currently necessarily designed to provide effective remedies procedurally or substantively. And ultimately, we need to find ways of feeding back into the system to correct decision-making at source that can ultimately entrench social injustice by design or by default. And that justice is currently invisible in much of the discussions that we see. Ultimately, what we're arguing is that if we ignore the testimonies of those on the ground, like those we've heard today, we do so at our peril. This is the type of evidence base that we need and that should be used to drive reform in relation to how we think about the future of human rights and the justice system across the UK's constituent parts. I'll conclude there, but I'd just like to take a moment on behalf of all of our co-authors to thank once again Just Fair and Bonavero for hosting the book launch, and a very special thank you to our panellists who shared their feedback with us today and their stories. None of this would, of course, be possible without the help of our funder, the Nuffield Foundation, our expert advisory boards that guided our entire research project. But most importantly, our thanks is to the research participants, those people that gave us their stories, their time and their expertise to explain to us what's happening on the ground. And we dedicated the book to the people who face the arduous access to social justice journey every single day. And we would urge once again that we listen to those testimonies in all the work that we do around the future of human rights and justice in the UK. Thank you.
Thank you very much, Katie and Diana. That was a very short summary of an incredible book. We're going to move directly on to some responses from academics. Before we have some time at the end for your questions, which I'm sure you have many. So I'm very pleased actually to introduce Professor Philip Alston, who I hope is there. Philip, can you see us? Yes. Hello there.
Hello.
Great. Philip is Professor of Law at New York University and, as mentioned, is the previous UN Special Rapporteur on extreme poverty and human rights. And Philip has kindly offered to chair this short academic panel in terms of responses to the book. So I'm going to hand over to you, Philip, to introduce the speakers and say a few remarks. Thanks.
Thanks, Jess. I'm very grateful to be invited to participate in this. I've witnessed many books being launched over the years, often on issues of social rights and so on. But there's no doubt that this book really makes a very, very important contribution. I've not often, maybe never, seen such a good combination of sophisticated theoretical perspectives, an important legal framework, and also rich empirical work being combined into a truly coherent whole. And I think the volume makes us all think about where we go from here. I was reminded, and this came up with some of Katie's later comments, of the Wreath lectures that Rutger Bregman gave over the last week or so, which were focused on the importance of values in society. I don't think he ever mentioned social rights as values, but the whole lecture series was a call to get back to a society that establishes itself, commits itself to values. And of course, the social rights dealt with in this book should be absolutely foundational in terms of that value-driven society. I think Katie's final comments were particularly interesting because there was a combination of identifying in a not such a direct way some of the major challenges that lie ahead in terms of the general move away from access to justice on the part of British government, the prospect that artificial intelligence will guide and perhaps even provide a lot of the remedies that we're talking about here, and of course the fact that an ever-growing part of the process is being outsourced to the private sector. All of those challenges should actually work fairly well with the really creative suggestions that came out of the book and that Katie summarized at the end in terms of the need to rethink the approach to remedies, in terms of the need for a much more comprehensive collective approach rather than plodding on with the sort of terrible individual experiences that we've heard about today. So it's a very rich agenda, not only in terms of documenting what has happened in the past, but also what the challenges will be in the years ahead. My main role is to introduce the two real commentators on the project. I'll introduce them both. Perhaps the first is Anashri Pillay, who I haven't had the pleasure of meeting, but who I know has been working for many years on precisely these issues. She's an associate professor at Durham Law School. She actually did her, having graduated from the University of KwaZulu-Natal in South Africa, she did her doctorate at UCL on justiciability of social rights and has been working on these challenges ever since. The second speaker is Colm Okaneda, and Colm is, what's your official title, Colm? Professor of Constitutional and Human Rights Law at UCL. Colm is one of those few academics whose every written work is worth reading. I can't make that claim myself, but I have never failed to learn from almost anything that he has written. He combines not just the academic role, but strong involvement in practical human rights bodies. So it's a great pleasure to have the chance to listen to the two of you. So Anasri, I'll hand the floor over to you.
Thank you, Philip, and thanks for the invitation to contribute to this book launch. Like others here, I'd like to begin by congratulating the authors on the publication of this important and timely book. It was a pleasure to have been involved in the early stages as a member of the expert advisory panel of the Nuffield funded project, and it is a great joy to see this book in print. I'd like to start by highlighting some aspects of the context in which the book was researched and has now been published. As has already been noted, the book grapples with key debates about the theory and practice surrounding social rights, and it does so in relation to the UK, where the legal landscape has historically been a hostile environment for social rights, where wealth inequality reportedly grew by 50% in the 8-year period from 2011, where significant cuts to social spending have resulted in ever-deepening poverty, and where international development assistance is being reduced to its lowest level since 1999. In conceiving of social justice as a journey that should end in an effective remedy, the book makes a valuable intervention in the scholarship. Historically, the recognition of social rights has faced huge obstacles due to what has been referred to as their poor cousin or Cinderella status, with separate international human rights treaties on civil and political rights versus social rights, and key differences in the approach to the implementation of these so-called categories of rights. It proved very difficult to shift that narrative. And so a huge amount of work had to go into challenging those received notions that social rights are not rights at all, and or that they are not justiciable. With the burgeoning social rights jurisprudence in national jurisdictions, particularly in the global south and particularly from the 1990s, though not exclusively, arguments that social rights are categorically non-justiciable became harder and harder to sustain. And so in the legal scholarship, attention turned to the effectiveness of social rights adjudication, with the scholarship increasingly focusing on remedies, dialogical approaches, participatory approaches, developing understandings of the content of the rights, and clarifying the obligations on the states, all of which helped to move the debate on. However, the focus on adjudication was increasingly critiqued, and it was time for a more holistic response. To my mind, this is where the key contribution of this book lies. The early chapters set out a well-thought-out conceptual approach that is carried through the book into the case studies and the recommendations. The marriage of rigorous analysis of the academic debates and the insights gained from empirical research is a real strength of this book, as several of the speakers have already commented on. The book is informed by this empirical research. The researchers interviewed practitioners whose work engaged closely with people struggling to access housing, social security, and or fuel and food. The consultants, activists, researchers, policy developers, volunteers, and legal practitioners were interviewed in order to better understand the gaps in access to social justice across the UK. Challenges, which is another strength of the book that's important to highlight. I've not seen this kind of in-depth coverage of all regions of the country before. Challenges to social rights are addressed in the book through the lens of deliberative democracy theory, which is hugely valuable in addressing concerns about the democratic legitimacy of social rights adjudication and the institutional capacity of judges. As the authors note in the introductory chapter, If rights claiming is an important component of citizenship, then genuine participation in a deliberative framework must address discourses that are constructed to marginalize and exclude. This is a refreshing way of interrogating tired assumptions about separation of powers, counter-majoritarianism, etc. The book does not reiterate the arguments about justiciability, rightly noting not only that these are covered in exhaustive detail elsewhere, but that expending so much time and energy on challenging basic skeptical positions about social rights hinders progress on their implementation. Instead, the authors consciously move the debate on to considering how principles of adjudication may address the critiques of rights. The book is fundamentally about identifying obstacles to achieving social justice across the UK and considering how those obstacles may be overcome. In offering this holistic understanding of what impedes access to social rights through the first-hand experiences of practitioners in the field, the book also speaks to broad critiques of rights as being overly legalistic, individualistic, and just plain ineffectual, especially when it comes to distributive inequalities. Critiques of human rights are not new, but those suggesting that we are witnessing the end times of human rights have become more prominent. Certainly, the movement is under threat. For social rights scholars and practitioners, it is usually frustrating to feel that having won a battle against profound skepticism about these rights, we now find ourselves in a world fighting deep skepticism about the value of rights in general. However you feel about current threats, whether we are witnessing an existential crisis or merely a moment of transition, what this book taps into is a strong sense that the role and value of social rights can only be understood through social rights practice. Furthermore, any real sense of the implementation of obstacles to the implementation of the rights needs to take account of the full journey towards accessing justice, from the moment of utilizing a food bank or talking to a welfare rights advisor, to accessing benefits, to instituting judicial review proceedings, to ensuring that remedies are implemented. In this respect, a key finding that emerged from the practitioners' stories discussed in Chapter 3 is that because social rights are not incorporated as legal rights, and I'm quoting here, all of our decision-making, appeals processes, and jurisprudence occur without the backdrop of human rights, short of ECHR claims. And this is where the greatest added value of social rights as legal rights can be understood. The absence of normative standards, according to international human rights obligations, cascades into a litany of violations in people's daily lives. An important part of making these injustices visible is to render them open to scrutiny. Social rights as legal rights provide a means to do this. As Rick put it earlier on, the idea that you might have a right to social security is revelatory. The idea that practitioners have to tie themselves in knots, making, for example, discrimination arguments because social rights are not directly protected in the UK, comes across very clearly in the chapters. This resonates with analyses from other parts of the world where the expressive value of rights is being recognized and the tools of rights implementation harnessed to further access to social goods and services. The conclusion of Chapter 3 highlights the disconnect between discourse, which suggests that rights are terminally flawed, and practice that continues to value its potential. Finally, the book is an antidote to the notion of universalist approaches to social rights implementation. It does many things well, including addressing justiciability debates and its coverage of international legal principles, but its key value lies in its fine-grained study of the UK context at every stage on the journey to accessing social justice. Congratulations once again, and to the audience, if you haven't yet read the book, I highly recommend that you do so.
Great. I'll kick off with my part. Thank you very much to Philip for that extremely kind introduction. Thank you very much to Anna Shree for doing my job so well and giving a comprehensive and really detailed summary of the book. Thank you very much to Just Fair and Bonavero for organizing this fantastic event. And thank you in particular to the book authors for producing an absolutely outstanding text. As Philip has indicated, I think this book is really exceptional because of the way it combines empirical, close-grained focus on the reality of justice deprivation for disadvantaged people in the UK with a sort of rigorous conceptual analysis that makes clear what the authors are doing, why they're doing it, and why their analysis hangs together as a cohesive set of arguments. So it's an absolutely superb text, and one which I've no doubt will be a key reference point in the UK and internationally for years to come. It's also a pleasure to read, I should say, which isn't always the case with academic books, perhaps. And the authors deserve immense credit for that. I'm going to pick out a couple of, I think, particularly salient points they make in the time I have available to me. First of all, I would identify the critique they develop through their critical discourse analysis of the fundamental injustice of the existing legal system within the UK as it relates to socioeconomic rights, the enjoyment of socioeconomic rights, and to basic socioeconomic justice more generally. The case studies set out in chapter 3, I believe, of the book are incredibly rich, detailed, and depressing, just because of how they get into the detail of how people in need, who with a just claim to support from the state, how their claims are squeezed out within the system, sidelined, marginalized, and how extracting anything from the system becomes an immense battle. And there's very vivid detail there, in addition to deep engagement with the structural and legal factors that produce this constructed disentitlement, so to speak. Other speakers have picked up on the phrase administrative mud, which I think is very, very graphic. And Katie emphasized how fear of retribution can be a real issue here. I'll also pick up something which I think is vividly illustrated by a quote from Mukherjee at page 217, which is what I call the slightly fake and fraudulent role played by appeal processes in these mechanisms, whereby much of the decision-making in these contexts comes with an appeal mechanism, which actually operates in effect as a sorting mechanism, whereby complainants who are better resourced, who have better access to legal advice, who are often middle class, are at least better able to construct legal argumentations. The appeal mechanism becomes a vehicle whereby those sort of claims are separated out from other claims, and by holding out the prospect of justice, actually acts as a sorting sorting mechanism, often sidelining the claims of those who are in most need. I should say I speak from personal experience in this. My eldest son is very severely disabled, and as many of you will know, at the moment, many local authorities across the UK have almost an 100% refusal rate when it comes to making SEN accommodations for particular categories of children with severe special needs. The appeal rate from some of those refusals is in the region of 90% success for claimants. So we have an entire mechanism that's constructed on first instance refusals, almost total 90% success in appeal rates. And of course, how that system simply operates is to filter out everyone without the drive and determination and access to resources to carry on through the appeal mechanism. And that's the simple reality of the day and the simple reality of the situation, as outlined in this book, but by other publications as well. But all of this is dressed up in the garb of a functioning and just legal system with appeal routes and so on. It's perhaps describing it as fraudulent is a little bit strong, but actually on reflection, not so much. I'll also highlight, picking up again from the case study examples, I'll also highlight the interesting role democratic decision making plays in all of this. It's very, very clear from the case studies, in particular those relating to Scotland, Wales, and Northern Ireland, but also in relation to England and algorithmic decision making, that much state decision making in this context operates in a way that's very, very impervious, both to the needs of claimants and individuals in need, not to mention, and also including their lawyers, but it's also impervious to many people trying to make the system a little bit better, to politicians maybe campaigning for change, especially in the devolved nations, activist groups, and so on. So much decision making is locked behind a bureaucratic wall. But simultaneously, the fact that this bureaucratic structure has received parliamentary endorsement is used to nullify legal challenges. So, and this has been particularly featured in recent UK Supreme Court decisions, where in cases like SC and very recent decision in Janzik, the Supreme Court has effectively said, you get no rights protection against decisions which have been authorized by Parliament. But to complete the picture, as noted in the analysis of the Telleriso case on page 108 of the book, there's almost no decent pre-legislative scrutiny of many of these measures. So in other words, everything is justified on the basis of elected politicians have signed this off, but there's no real possibility for real democratic debate and discussion of many of these structures. So we see how the sort of constitutional language of democracy actually ends up locking many of these decision-making behind a wall that closes off the possibility of legal challenge, that closes off the possibility even of activists and pressure groups and the people most affected by this decision-making having any meaningful say in the laws that affect their lives. All of which I think makes the central argument in this book, the need to recognize the importance of bringing socioeconomic rights into the picture and making access to justice real instead of being a somewhat fraudulent fake structure, making access to justice real, making access to justice in respect to socioeconomic rights real, all the more important, because it is the legal language of rights and the conceptual language of rights and the political claiming language of rights that remains our best tool for challenging that sort of wall of indifference, which results in so many people being denied fundamental human entitlements. And it's an argument developed brilliantly in the book and set out incredibly well, great clarity in the recommendations at the end of the text. I'll conclude on two final points. The book makes a very, very important distinction when talking about access to justice. Access to justice has to involve more than a mere formal ability to bring a claim. You know, you can bring in a social welfare tribunal appeal, you can bring judicial review, great, that's access to justice, job done, no more issues. That's nonsense. It's a purely formalistic approach to access to justice, which then becomes a sort of justificatory cloak for a fundamentally unjust system. The book cuts through all of this, going right back to Garth and Capoletti's seminal 1978-1979 article on access to justice, which makes the point that you must be able to access legal procedures, but also those legal procedures must be capable of generating a fair and just outcomes. And that, I think, is an incredibly important point, and it's the argument this book develops brilliantly in talking about access to justice. And finally, I'll return to this point about how the book brings empirical experience, concrete evidence to bear on an attempt to sort of reconceptualize our whole legal architecture and how law and administration operates in this context. And it does so with great force. And the authors are to be commended in writing, putting together such a superb research project and generating such a seminal text that I've no doubt, again, that we'll all be referring to in our different capacities for many years to come. Thank you.
Thank you very much, Colm, Anishri. Philip, would you like to say any final remarks on that section?
No, I think they were excellent, and I endorse all of the very complimentary remarks made. I think this is really going to be a text that many of us will turn to in the years ahead to reflect on the existing shortcomings and the challenges that we need to rise to. So many thanks.
Thank you. Thanks again, Philip, for introducing that session, and to Colm and Anishri for their contributions. Okay, so we now have a little bit of time for questions from other participants, from all of you listening along. I think my colleague Helen has been keeping track of the questions in the Q&A, and we've got some of the other authors appearing on your screen. So Helen, are you there somewhere? Are you able to give us some sense of some of the questions that have been posted?
Hello, yes, I am. And sorry if I have not highlighted all the authors yet. I will get to you. I'm trying to do more than one thing at once. We have 2 excellent questions in already, but please do keep posting them. We have one on, and I think this administrative mud term has really struck with people. So Alice Donald asks, the administrative mud, and I'm summarising, do the panelists think that the entrenched problems can be solved without fundamental redesign of welfare, e.g. universal basic income or minimum income standards? And then we have another from Claire McGillivray from Making Rights Real. And Making Rights Real, they're seeing active negative behaviour duty bearers towards rights holders who raise their voices speaking truth to power. So they're noticing a pattern in some of those duty bearers' responses, talking about gaslighting and undermining without legal or any other frameworks for protecting human rights defenders. How can we practically address these issues alongside the communities that they're already serving?
Thanks, Helen. Katie and Diana, do you want to start with any responses to those, and perhaps other authors might want to come in?
I'll very briefly start, but I would invite any of the other co-authors that'd like to say something to come forward, and likewise the panelists. So I think these points are interrelated. I think what we see is it's very difficult to align the existing system with Garth and Capuletti's, equally accessible processes that can lead to effective socially just outcomes unless we have some normative standards in there. I think there is a debate to be had about how those normative standards are created, but I think the way that we currently reflect on what's happening with human rights discourse and the rise of populism, and which is so largely connected to socioeconomic disenfranchisement, we have to start using social rights and international human rights law as at least a normative guide. So you can have domestically conceived and developed standards and frameworks, but the right to an effective remedy gives us a really good place to start to test whether or not justice mechanisms are operating in practice, and our economic, social and cultural rights framework. And no framework is a panacea, but it certainly gives us a decision-making framework we can use to help test whether or not the existing administrative mud that people get mired in is as a result of the fact that we don't actually have these normative rights embedded in law. And that then relates to Claire's question, which is this real difficulty that we saw. And Claire is one of the inspirations of this book in terms of the work that she does on the ground in Making Rights Real and understanding the power of collective action. But it relates to the point that we individualise collective injustice. And I know that in the work that Claire was involved with in Leith, one of the problems you see is when there was collective injustice around housing issues, people had to raise their claims individually, and the council was able to then sort of bounce that back. And so there is an ethical question around the rights reclaiming when we don't yet have the normative standards. So the way that I look at it is that social injustice will always be a struggle, and we have to work consistently together, but it's the responsibility of those who do have more power to reclaim these rights, to try and lessen that burden on those people who are at the cold face of the rights violations, and that these things have to happen concurrently. So claiming rights whilst also being honest with communities about the dangers of not yet having normative standards established, but still being able to explain that rights claiming can be powerful. And a lot of our empirical research demonstrated that collectively, when that did happen, even when judgments weren't won, hearts and minds were, and we saw that across all our case studies that we looked at. I don't know if anyone else would like to come in on those points.
Any other speakers want to contribute, say anything on those? That's okay. Oh, sorry, Diana. Yes, go for it.
I was just going to add to sorry, to Katie's points, that it also goes back to this notion of fear of retribution. That when individuals do raise challenges, and we saw this particularly when we spoke to practitioners in Northern Ireland within the private sector, housing sector, for instance, and lack of accountability, and that even when penalties were applied, they were so low that they actually didn't make any difference. So I think that's a really difficult question, sort of in the mix of all that, in terms of raising challenges and how communities and individuals deal with that aspect of things. But it does go back to the accountability structures that need to be in place in order to protect individuals and protect rights holders. So that was just one minor point I thought I'd add.
Thank you, Diana and Katie. Thank you. I think we've got time only for one more cluster of questions. Helen?
Well, thank you. I thought you were going to say one more, and I was like, can I have two? We've got a question from Jen Clarke here, who would love to hear the author's reflection on what we need to do quickly to counter the rise of anti-universalist sentiment of populist actors who are weaponizing economic, social and cultural rights to claim rights should be conditional, for example, on citizenship, work engagement, etc. And then Luis Llanes says, congratulations, of course, and on the theme of a lack of feedback loops, what are the author's views on the responsibilities of both judicial mechanisms and scrutiny bodies to have clear, strong mechanisms of follow-up recommendations and implementations? Do we need regulatory changes to ensure this in the long term?
Thanks, Helen. Who would like to take that? Katie, you could start again, and then maybe other people come in.
Yeah, and I would be real keen to hear also from our panelists on Jen's question, because this is a problem we face globally, as well as in the UK, and it is very much on our doorstep. I think the reclaiming the language, but ultimately the narrative, and being mindful of how we perpetuate harmful discourses. So maybe Diana could speak a little bit more about this, but when we talk about reclaiming the narrative, what we are also doing is not couching our arguments around human rights reform in response to the scepticism and negative proliferation that's seen in the media, because ultimately the empirical evidence demonstrates what's happening on the ground is completely different to the claims that are being made by those who are weaponising and mobilising those sentiments, and that ultimately socioeconomic deprivation is a big factor that is helping to fuel that weaponisation. So it's both a response and a solution. And then on Louis' point, again, others may wish to come into that. I think there's so much that can be done to correct feedback loops, and that really we should be enabling them across all of our justice frameworks. So I think of it as like routes to remedies and pathways that can run concurrently, and we should be exhausting all of them. So judicial routes is obviously one people speak about a lot, but nearly everybody that we speak to says people don't want to have to go to court. So non-judicial routes are so important. The whole the fourth branch that we hear, the likes of Tushnet's work around and Brackerman around fourth branch accountability and regulatory frameworks, the experience of South Africa in terms of supervisory jurisdiction, again, not necessarily anywhere that there's a panacea, but that we should be embedding checks and balances in across Parliament, government, judicial bodies as well as that regulatory and administrative sphere. And that can include people like the Commission, for example, performing some kind of supervisory role. But the court, and for example, again in Scotland, already is able to do that via rules of court and so on. So there are innovative interventions we can do sooner rather than later, but ultimately it should be embedded using those interventions or via changes to law and policy. I don't know, maybe if Gaurav or Aidan might want to come in on that point, and Diana on the mobilisation of language and narrative.
We'll have to be quite brief on these final contributions, panelists, and yeah, over to you.
Okay, I'll jump in then. So just with regard to the narrative, I think one of the main points we try to make is that the language we use is really important, and sometimes we're not even really conscious of how we reproduce some of these categorization narratives. So, for example, one of the advocates that we spoke to, sort of in an offhand comment, but she said that one of the persons she was supporting wasn't the sort of person who was in trouble or wasn't a problem for society. And she said it in terms of advocating for the person, but at the same time, you know, we unconsciously sort of reproduce this narrative of somebody having to be a good person, or, you know, in order, and it's not at all what she meant. She was, you know, she was a brilliant advocate for the person she was advocating for, but it was just to highlight that the language we use can be really both helpful and it can also be quite destructive. So it was just trying to highlight some of those dynamics. And of course, that none of this sort of reclaiming of the narrative, you know, it has to go hand in hand with, you know, addressing all these structural issues. You know, it's part of the solution, but there's awful lot of work that still needs to be done. Thank you.
Thank you, Diana. Thank you so much. I'm conscious of time and we're nearing the end. I just wanted to ask Rachel to just come in to see whether, as the co-host, whether Rachel, you'd like to say a few words before we thank all the speakers and participants and close. Rachel, I don't know if you're there.
Yeah, thank you. I'll be very, very brief, conscious of the clock ticking. I think what the presentations today and the book stresses, in a very polarised context in the UK, on the discussion on human rights, the idea of being treated with respect, the language of human rights still has such importance and relevance. And I think the book and the presentations reiterate, and what's been seen from the individuals that the authors have spoken with, that the sort of perception of remedies, what's needed, is that which is set out in international human rights law. And I think Katie articulated that so well just now. Also, I think what the presentations today have done and the book is humanise and personalise these challenges, which is, I think, crucial in the current very divisive debate about human rights. And finally, I just want to go back to Rick's comments at the start about hope, whether this is the resilience shown by those that the authors have spoken with or the creative approaches adopted to support and advise people. I think that's important to keep in mind in what can feel like quite bleak times. So thank you once again. Thank you for enabling me to speak, and congratulations to the authors on this fantastic publication.
Thank you, Rachel. And it just leaves me to thank all the speakers and contributors and all of you for attending today. And also to say, I think the book leaves us all with a very clear call to action. So I would very much recommend reading it, and do join us in Just Fair in trying to push forward some of those recommendations. So thank you again for your time, and this will be available this recording will be available for you to watch back at your leisure. So thank you all again, and goodbye.
Thank you, everyone. Bye.